Hello, I'm Ann P. Mitchell, attorney at law, law professor and law dean emeritus, and founder of WeThePeopleDefend.org, defending and taking back our democracy. Let's talk about the May 16th Supreme Court order stopping Trump from using the Alien Enemies Act in the Texas case. And no, the Supreme Court never said that Trump could use the Alien Enemies Act. That May 16th decision was 7-2. The two justices that dissented were Thomas and Alito. The case came up through Texas because a group of Venezuelans in detention in Texas were about to be deported under the Alien Enemies Act, also known as the AEA. The specific issue, and the issue on which the Supremes based the order, was that the Venezuelans were told just mere hours before that they were about to be deported. This decision, and also the earlier decision in April involving Trump's use of the AEA, are about, and only about, due process, not whether Trump can use the Alien Enemies Act at all. In the earlier ruling in April, which was in a different case, the Supreme Court did not stop Trump from using the AEA, but they also did not say that he could use it. They simply said that due process required adequate notice. A few hours is not adequate notice. In the recent May 16th decision, the Supreme Court said that it is up to the lower courts to determine what exactly is adequate notice. Certain lower courts have given orders saying that a particular plaintiff must be given 21 days' notice, so I expect that may end up being where we land on what is adequate notice for deportations, at least in these cases. The important point is that the Supreme Court never said that Trump is allowed to use the Alien Enemies Act. In fact, they have not opined on that question at all one way or the other. This is known as deciding the merits of the case, and they have not yet decided the merits of Trump using the Alien Enemies Act, i.e. the legality of it, because that case has not yet come before them. And in fact, in the most recent Supreme Court ruling and order, they took great pains to make that clear, saying, quote, "To be clear, we decide today only that the detainees are entitled to more notice than was given on April 18th, and we grant temporary injunctive relief to preserve our jurisdiction while the question of what notice is due is adjudicated. We did not in April, and do not now, address the underlying merits of the parties' claims regarding the legality of removals under the Alien Enemies Act." So the Supreme Court is telling the lower courts, in essence, even though we do not yet know whether it's legal for Trump to use the AEA, while he is using it, you need to be sure that people get due process. I don't know when or with what case the Supreme Court will finally address the merits of using the AEA. What has to happen is that the right case has to work its way up, or percolate, to the Supreme Court. Right now, the cases before the Supreme Court have been about the lack of due process. The thing is, the case that will finally address the AEA on the merits has to be the exact right and perfect case, because we only get one shot at this, and the wrong case could potentially end up with a ruling that he can use the AEA if, in that given case, there is no other way possible for the court to rule, given the law, the Constitution, and the facts underpinning that particular case. This is Ann P. Mitchell, attorney at law, professor of law emeritus, and founder of We the People Defend at WeThePeopleDefend.org. Join us